Achha, everyone can hear me. Okay. Now, see, this whole, discussion, the very purpose of the whole discussion is to basically, solve the previous year paper and help you out with that. Okay. Now, I have already discussed, for UPSC 2020 paper 1, 5 questions, right? So, I mean, there's total 8 questions, 4 from constitution and administrative, and 4 from international law, right? So, question number 5 I have discussed. In that there was 5 subpart. Similarly, I'm going to discuss question number 6. It have 3 questions in it. Okay, so we'll discuss that. Now, some of you are messaging with regard to videos, right? That where the videos would be available, right? So it is available on DeFactoIS website, right? Or the best thing that recently they have launched an app also, right? DeFactoIS app, right? So on that also that video is freely available. Okay, so you can go and download their PDF, etc. Everything is there. Okay, of this thing. Okay. Okay then, so let us start with the class today. So we have question number 6A, 6B and 6C. Okay, so let me share the screen with you. You will understand it much better, Fana. Now, once I am done with this particular topic, right, then in the last we will have a question answer session, right? So if you have any question, you wait till last to ask. Okay, right? Yes. So that is how the thing will function. So let me share the screen with you. Okay. Now I think it's proper. Yes. Now remember that this is question number 6A, B, C of 2020 paper. Okay. So and by the next week I will complete paper 1. Then by the next week we will complete paper 2 as well. Okay. Yes. Now again, same thing is available on their app. Okay, on DeFactoIS app on Android. I think iOS they will launch in a week or so. Okay, so Android they have launched. There you can see that. Okay. Yes. So let me talk about it. Question number 6, what does it say? Is in the resolution 1619, right? So it seems to be a current affair question, right? But basically it is connected to our topic, right? So in the resolution 69/19, now there is 99% of chance that you might not have studied this resolution, not at all, right? But the question is so nice that it itself tells what this resolution is all about, right? So even though you might not have studied this particular resolution, still you can answer it, right? Let us see how. It says the United Nations General Assembly decides to accord to Palestine a non-member observer state status in the United Nations. It means that this resolution was about this. Okay, now you no longer required to understand the nature of that resolution. Okay, I mean the content of that resolution. The resolution was about this itself. It gives you ample understanding of the resolution or the major point of the resolution. Now the main question is that explain the importance of the resolution while determining the statehood of Palestine. Analyze your argument in light of various theories of recognition. Right, so this is a question with regard to recognition, right? And that resolution gave certain type of recognition to Palestine by giving them an observer member status in UN, right? So the question is basically you have to justify whether that act of the UN will include exact recognition of Palestine under international law or not. Okay, now you must be knowing that there are 2 types of recognition system, de facto and de jure, or you can say declaratory theory, right? That when a state comes into existence, right, then in the case of that is the form of recognition, de facto and de jure, right? But this is basically the principle behind or the theories that we follow with regard to recognition, right? So there are 2 theories, right? You must have studied it. First theory says that only when the state is recognized it comes into existence, right? And second theory said that no, existence of a state is irrelevant. Okay, existence of a state is irrelevant. I mean, recognition of a state is irrelevant. Once a state comes into being, it doesn't matter that whether you recognize it or not, right? So recognition is merely a recognition of an existing fact, and the existing fact is that a state already exists, right? So declarative theory suggests that declaration simply means you are recognizing an existing fact. That's it. It is not creating a new state in itself. Okay, right? So let us see that whether this particular, how to approach this particular answer, right? So you explain this, right? You can, a little bit talk about historical aspect of Palestine, right? That how it was created, right? And then you can, right now, remember this is a 15 marker question, okay? And then you can, in the beginning, in the major part, you can talk about the resolution, right? And resolution importance you can talk about in the sense that even though it do not have a formal membership, it is the first stage of being a formal membership. Okay, so the importance of resolution in that sense you can talk about. Understood, right? So I have given the whole paragraph here. Now the next part, that is the most important part, is that how or in which particular theory of declaration, which particular theory of recognition actually fits in. Okay, so we will give a separate heading, and then you will talk about the demands a discussion on declarative theory of recognition. Okay, that if you declare a particular state to exist, right, that doesn't matter that state will only exist after your declaration. Okay, right, so that theory of discussion you can type right here. Okay, and in the end, if you want to do the conclusion, you can say that it may amount to steps towards final recognition of Palestine under international law. Okay, see, and you are supporting your answer with the argument also, right? That it means, see, when it says that you discuss the various theories in light of your argument, right? So you have to basically write the rationale behind the declarative theory. Why declarative theory, right? Because something do not cease to exist just because you have not given it importance, right? So that doesn't happen. Okay, understood? In any fact. Okay, so in fact you have to justify that declarative theory is a correct theory. Okay, and this act of the UN is in pursuance of that declarative theory itself. Understood, right? So that is how I have analyzed it also. Okay, so you can write that down in the answer, and it is exactly 300 around words. So even if you read it and you can write 250 words, that will be more than sufficient. Okay. Now questions I have told you, wait for the question in the end, right? Right now I'm not taking any questions, right? So please wait for the question in the end. Okay. Someone is asking, will you apply it on Telegram? No, it is not on Telegram. I told you it will be there on De facto IS app. Okay, you go there and download the app and enroll yourself. Okay. Now let's come to the question number 6B. Again, a very easy question, I must say. Now question number 6B, if you remember, it actually says that asylum ends where extradition begins, right? Asylum ends where extradition begins. Distinguish between territorial asylum and extraterritorial asylum, right? So it means you have to explain both of them individually, and then you have to find connective link and little bit go into more detail about the meaning of asylum. That's it. Okay, so asylum ends where extradition begins, right? So what is asylum, right? Then you write that once a municipal process of asylum is finished, right, and that may be finished either under international humanitarian law or either other country demands your presence in their native country. Okay, so once the extradition begins, it means that formally one state have ended the asylum. Okay, now you did not to go into the very nitty-gritty of asylum and what are the various principle of extradition or asylum, right? That is not needed. In fact, in the case of extradition, you must have seen there is a double criminality principle, right? That if the extradition happens generally under international law only when there is a crime, and that crime is a criminal act in both the countries, right? The country who is giving extradition and the countries who is taking extradition, or the country to whom the extradition is being done, right? So you have to introduce the concept of these two. Very simple, right? Nicely you can introduce it, right? And then you have to explain both the thing in detail and highlight the difference. Difference highlighting is important. I've given here also, right? Consideration behind asylum, right? So I've given very detailed here. See, the purpose is that if you read this and if there's a question specific to extradition, this answer can be written. Okay. Similarly, you go to asylum in detail. Okay, it involves two elements I have already provided, right? So you have to you get the legal protection and a shelter actually, right? So you get a territorial space and a legal protection, right? So that is the major element of asylum. Now there are two types of asylum that have been specifically asked, right? So you have to discuss them separately, right? Territorial and extraterritorial asylum, right? So in the case of extraterritorial, it is basically beyond the territory of that particular country in its own jurisdiction anywhere if they have anything, right? Like for example, in foreign embassies or in foreign ports where their ship is lying. Okay, so it means if there is a floating continent, in the sense in the legal sense, if there is a floating continent, right? So their asylum can be given, right? So that is referred as extraterritorial asylum. The best example is Julius Assange was given asylum by Ecuador embassy in UK, right? So that was the extraterritorial asylum. Okay, so extraterritorial in the sense that outside the exact territory of that country. It doesn't mean that outside of the territory and the other territory do not belong to them. No, the other territory also belong to them, but they belong to them only in legal sense. Physical sense, they are present outside the country. Okay, that is the meaning of extraterritorial asylum. Okay, so you have to ask the difference, and then you have to talk about interplay between them, that how when asylum ends and the extradition starts. Understood that particular point? Okay, right? So it means that once a country process your extradition request, it means that country is legally saying that you are now no longer will get the protection of our law or our land, or you are no longer required to live in our country. Okay, right? So once the asylum ends, the extradition starts. Understood that particular point? Okay. Yeah, so that is, the you're talking about. You can give the recent example of India also, that it have acquired importance with economic offenders, right? So those sort of stuff also you can write here, right? It have started for economic offenders. Okay, and you can give examples. You must be knowing the examples, right? Media have made sure that you will know the example. Okay, now let us come to the question number 6C. Again, a very interesting question. It says, do you agree with the view that international law is merely a positive morality? Discuss the nature and scope of international law. Now remember, when we have this question can be asked indirectly. International law is a positive morality. 2019, the same question was there. Right? So ultimately, the question demands to know that whether international law is a weak law or not. Right? So either they ask it is a weak law, either they ask it is a positive morality, or either they ask it is the vanishing point of jurisprudence. Right? So whatever the question may be, the argument will remain the same. Right? What will be the argument? That see, actually, when we talk about normal law, so it is considered as a command of sovereign, right? You must have studied Austin, right? So what is the fundamental block of that particular definition? That it is always, that law is always backed by sanctions. If there is no sanction, the law will not be obeyed, right? So that is the primary rationale behind that particular statement, right? Now, if you apply the same statement in international law, it lacks two things. First, it lacks there is no sovereign. Okay. Second, it lacks that it do not have any sanctioning authority, right? So both the critical element is missing, and that is why this argument, it is merely a positive morality, or it is a weak law, or it is the vanishing point of jurisprudence, right? So it means the fundamental argument behind these three questions, always repeated. Each year you will see one question at least: vanishing point of jurisprudence, positive morality, or weak law. Right? The argument remain the same. You talk about Austin in general, right? And these two critical things are absent. Okay, and then go on arguing that whether it is a positive morality or not, right? Now, same thing I have given here, right? Same thing. The law cannot be if there is no sovereign. Same thing. Now, now the question of this positive morality ends here, right? But suppose you have to support this argument, right? So what you will write here actually is that when we talk about international law, or any law for that matter, so what you are assuming that once they have a sanction, then only that law is a proper law. If there is no sanction, the law is not a proper law, right? Now, does it means the negative is also true? Meaning that if there is a sanction, right? If there is a sanction, it means that law would always be followed. That is also not true, right? So it means the absence and presence of a sanction does not make a law a proper law. Why? Because it do not guarantee that law would be followed. Like for example, we have death sentence for murder. But do you think death do not occur? Is it still murder do not occur? Still the murder occurs, right? So it means the presence and absence of sanction does not mean that law would be enforced or the people will follow that law. It doesn't mean at all, right? So it means a sanction makes no relevance in determination of the weakness of a law. There are sometimes laws which do not have any sanction, but still people follow it, right? So how you determine it is a weak law or a strong law? People follow it or not, right? People think whether it is a law worth following or not. Understand that particular point? So in that sense, you can argue that presence and absence of sanction do not make any sense. Okay, and then you can talk about customary law. That customary law, there is no sovereign authority, there is no sanctions directly, but still that is found. Okay, so when you have to argue against, you can point to that. Okay. Now this question, that thing need not to be written, but I have told you because there are three questions which are similar in nature. Now similarly, you have to discuss the nature and scope. Now nature basically it is pointing to this itself, right? There is absence of sanction, there is no presence of sovereignty. Now scope simply means where does it apply? Whenever the question is the scope of this article, then you have to write that where does it apply. Okay. Now, what is the scope of international law, right? So I have given here, right? Interstate relation is regulated, international organization, non-state actors, individual in international law. Now, there is sometimes a specific question also to discuss the importance of individual under the international law. Understand that particular point? So that specific questions can also be, answered with this particular answer. Okay. Done, right? So understand the difference between nature and scope. Both are not same. Right? Nature and scope is not same. Whenever there is a question with regard to scope, so they want to ask you that where does it apply? Okay, what are the conditions in which it will apply? What is the subject matter of that? Okay, so that is the meaning of a scope. Understood? Okay. So remember that this question is very important. Each time repeated. Okay. So there's three things. Again, I am repeating: international law is a positive morality, vanishing point of jurisprudence, and the third thing that they ask is whether it is a weak law or a strong law. Understood that particular point? Okay. Yes. So that will be all for this. Now I will, take questions. Right now I will take questions. Now this three question is over. Go ahead. If you have any question, go ahead, all of you, and you can ask me. Okay. Go ahead. You can raise your hand here, right? And I will, sort of, I will unmute you and you can ask the questions. Okay. Go ahead. You can raise your hand and you can ask your questions. VP. पूरा नाम तो आप लोग लिख लीजिए, VP जो है. Yes, Mr. VP, go ahead.
Hello.
Yes, हाँ बताइए.
Sir, I have question regarding the third question. That question is: do you agree with the view that international law is merely a positive morality? I have two issues. First, just to agree with one aspect that yes, it is a positive morality, and not the law as it is. Is it good or not? And
no. See, if the question wants you to take to a particular view, right? So either you agree or the other you disagree. Okay. Can you hear me, VP? You can type yes, I think. Okay. Sachin is asking a question: is S.K. Kapoor enough to cover international law? S.K. Kapoor, there are some of the topic is correct, right? Some of the topic is incorrect. And there's some of the topic which is not present itself. Right now, see, I have already told you, international law is very, very vast. Now, if you go on reading S.K. Kapoor, it will take a lot of time, right? So what you do that you point out certain chapters, okay? Go through that, that de facto law, there is a specific in international law. I have given some PDF also. That if you study those PDF, that would be more than sufficient. No need to go on, and reading everything. Okay, now for some of the chapters, Pierre Kapoor is good, right? In fact, Stark international law is much better, in my opinion. Okay, so that you can see. I have given there, topic wise I have given, which topic you have studied from which book. That also I have given. Okay, you go through that once. Yes, Sachin? Okay then. Any other question or should we proceed with no other questions? Anyone? Any question you might ask me, that is not an issue. Go ahead. Dhavant Mishra. Yes, Mr. Mishra. Geeta, I will come, not to worry. Yes, Dhawan, tell me.
सर जो क्वेश्चन ज्यूरिस्प्रूडेंस पे था, सर उसके लिए सर कौन सी किताब सही रहेगी ज्यूरिस्प्रूडेंस के लिए?
ज्यूरिस्प्रूडेंस पे कौन सा क्वेश्चन था इस टॉपिक में जो भी मैंने डिस्कस किया है?
नहीं सर, मतलब सिलेबस में.
सिलेबस में तो बेसिकली वो ज्यूरिस्प्रूडेंस पे द मेन क्वेश्चन है विद रिगार्ड टू द मीनिंग ऑफ रूल ऑफ लॉ, राइट? The meaning of rule of law. तो उसके लिए I think that will be covered under separation of power concept of administrative law itself. उसमें jurisprudence का कोई टॉपिक या सच नहीं है, ठीक ना?
जी सर.
तो administrative law में पढ़ सकते हैं. They need not to be jurisprudence, not at all. Yes. Now one more guy is asking question. Let me. Geeta. Yes, Geeta, go ahead. I have unmuted you. Go ahead, ask your question.
Good evening, sir.
Good evening. Tell me.
Sir, whether I have to firstly give preference to study the important weightage topic, or else I just to go through the starting page to ending page, sir? Whether it
only see when you in UPSC, if you will see, most of the questions they want you to write rationale behind it. Why asylum? Why basic structure doctrine, or why do you think rule of law is a good thing, right? And that is mostly in the introduction part only. Right, so first 2-3 pages is actually very relevant, and then rest when they divide it, suppose territorial and extraterritorial asylum, right? So for that, even reading the first 1-2 paragraph of the heading will suffice. No need to go. Suppose for extraterritorial asylum they have given 5 pages, so for your UPSC the first 1 to 2 paragraph would be more than sufficient. Got my point? Okay, so instead of reading the whole 5 pages on extraterritorial asylum, that is not needed at all. They might have given multiple examples about it, not required at all for our purpose. Okay, so be very smart in the study. That is actually very important. Okay, any other one, any other question, or should we proceed to end this? Tell me. How to self-evaluate answer? That is a very tricky thing, Mr. Acha, his name itself is law optional. Okay. That is a very tricky thing to self-evaluate. See, what you can do that you can make group actually. Yeah. Take 2-3 people, okay, and give each other the feedback. Self-evaluating is always against rules of natural justice, right? You cannot be the judge of your own cause, okay? So self-evaluation, in that sense would not work, okay? So better to take 2-3 people and group study. That will be much better. Okay, Mister. Soumya is asking that can be in that. Yes, you can see that recent economic offenders. You can, if you want, you can write, or otherwise, simply talking about recent economic offender would suffice. And in fact, even if you name 1 or 2 of them, that doesn't matter. Yes, word limits do matter. Word limits do matter. You can exceed by 10%, but not more than that, right? Not more than that. Okay. Chaliye. So let us wind it up for today. Okay, let us meet on Monday. Okay, and now again, these things will be on De facto IS website, or sorry, De facto law or De facto IS this app. Okay, you can go and see there. Okay. No questions I'm unable to handle. That much amount of question not possible, right? So whatever you question have, you in this sessions, live session, you may ask me individually. I won't be able to reply. Okay, that is simply impossible. Okay, please excuse me for that. Okay, Chaliye, that will be all. Thank you. Thank you. And any problem, you can email Mayank, defactolaw.in@gmail. He will be able to answer that. Okay, done. Chaliye, let us wind it up for today. Thank you. Thank you, everyone.